Good evening. My name is Regina Chavis. Kelsey Walker and I would like to thank you for attending this presentation on wills and advance directives. You can go to the next slide, Kelsey. We want to remind you that this presentation provides legal information only. This is not legal advice, and we are not your lawyers. Next slide. So, who needs a will? Everyone can benefit from having an estate plan. No estate is too small. Having a will allows the testator is the person who creates a will, to control what happens to his or her belongings after death. And having a will helps to alleviate some uncertainties. Next slide. Why is estate planning relevant to disaster relief? Well, when a person dies without a will, state law determines who owns any property that is left behind. The property may pass to several individuals jointly. The property may pass to non-relatives. And when multiple individuals have ownership interest in property, it is very difficult, or can be very difficult, for them to agree on how to use or maintain the property. So that's relevant to disaster relief because often in a disaster, decisions have to be made about the property. It can be difficult to get two people to agree. So it can be very difficult if you have 13 people that have an interest in the same property. So this is why having a will is very important. Next slide. So what is a will? A will is a legal document that directs what should happen with your real and personal property at your death. Next slide. Who can create a will? Anyone over 18 years of age with a sound mind can create a will. Have a funny story. Well, not so funny. A couple of years ago, when my daughter was 16, she injured her knee and she had to have knee surgery. And so as they were rolling her into the room away from us, she told me, "Mommy, if I don't make it, I have a will and it's under my bed." So it's sad to say that that will would not have been valid, but she did create a will. She was only 16. So in order to create a will and for it to be valid, you must be 18 years of age with a sound mind. Next slide. What are the different types of wills? North Carolina recognizes three different types of wills: attested wills, holographic wills, and oral wills. So the first type of will is the written attested will. That will must be signed by the testator, that's the person who creates the will, two witnesses, and it also needs to be notarized. And these signatures need to happen in the presence of a notary. A holographic will is also accepted in North Carolina. It's a handwritten will and it must be in the handwriting of the testator. It must include the testator's name and or the testator's signature somewhere on the will. An oral will is a will, of course, that is made orally by the testator on his or her deathbed. If a person makes a will, if a person is on their deathbed, or they believe they're on their deathbed, and they make an oral will to say how they want to dispose of their property, if they do that in the presence of two witnesses and then they die, then that is actually valid. If they orally say how they want to dispose of their property and they think they're about to die and then they don't, then the oral will is no longer valid. Next slide. What should you do after you create a will? First, make sure you sign the will in the presence of two witnesses and a notary. Also, have the witnesses sign the will in the presence of the notary and then have it notarized. You need to file the will with the Register of Deeds in your county, or Store the will in a place where you keep your important papers so that upon your death, someone will find it. So put it in a place where people will look for your important papers through your important belongings. Or you can leave it in the possession of someone that you trust. Next slide. Can a will be changed or revoked? Yes, it can. How? The testator of the will can destroy the will as long as it's being destroyed with the intent of revoking or destroying it. The testator can also direct someone else to destroy it in his or her presence, and that revokes the will. Anything that was on the will is no longer valid. A previous will can also be revoked by creating a new one. So if you want to change a will, it's good to destroy it. You can also change a will by creating a new one and making reference that the old one is no longer valid. Next slide. What happens if I die without a will? Dying without a will is called dying intestate. When you die intestate, your property will be distributed to your heirs according to the law. And that means that the law determines who your heirs are. Now, generally, this will include your spouse, children, or grandchildren, then parents, and possibly your siblings. But a common misunderstanding, and something that one reason why it's very important to make a will, is that the law does not guarantee that property will be distributed to blood relatives. So people hear heirs and they believe, oh, my family. But the law determines who your heirs are. And if there aren't people in your family to take, it is possible that the property may be distributed outside of your blood relatives. And that's all. Kelsey?
Oh, excuse me. Oh, did you want this?
Sorry, one more.
Sorry.
How may property be distributed in my will? Generally, you can leave your property to anyone you want to. You can divide your property however you wish. And you also don't have to let people know how you're dividing your property. If you feel like people may be upset, then you don't need to let people know, but it is your property. You may divide it and dispose of it as you wish. You can disinherit people. You can leave everyone out of your will except for your spouse. If you try to leave your spouse out of your will, then they can, by law, ask for the spousal share. So you can't disinherit your spouse in North Carolina, but you can disinherit your children, your grandchildren, or anybody else that you don't want to leave property to, because it is your property and you determine who gets what in your will. And now, Kelsey, I think it's really on you.
All right. Thanks, Regina. As Regina said, my name is Kelsey Walker, and I'm here today to talk about advance directives. So what is an advance directives? An advance directive is a legal document which helps you and your loved ones make decisions if you are unable to do so. Today, we're going to talk about 3 different documents that fall under the umbrella of advance directives. And this is the power of attorney, healthcare power of attorney, and the living will. The first one we're going to talk about is the power of attorney. This is probably the most well-known in that you've at least heard the name thrown around before. A power of attorney is a legal document which gives someone legal authority to take certain actions for you. That person is known as your agent. Sometimes they're also called an attorney in fact, but agent is the more modern term and is the term that's actually used in the black and white law right now. So that's the term I'm going to use today. When you create a power of attorney, you decide what the agent is authorized to do for you. But once they are given that authority, anything they do in your name is as if you did it yourself. So if you say that your agent can write checks for you and they go and write a check, it's as if you wrote that check yourself. So you want to make sure that your agent is someone you trust and that you don't make a decision to have an agent lightly. That's kind of a common theme with all advance directives we're going to keep saying today. But why would you want a power of attorney? Having a power of attorney ensures that the person you want to conduct your business affairs for you is the one making decisions for you if you are unable, and it can also prevent a need for a guardian. So what will a power of attorney contain? Something I kind of already alluded to is that a power of attorney can do pretty much whatever you want it to do. And the first part of that is deciding when it becomes effective. There are two types of power of attorney, generally speaking. The first is a durable, and the second is a springing. So with a durable power of attorney, the document is effective as soon as it is signed, and it is going to remain in effect even if something happens to you. By law, a power of attorney will be durable unless it says in the document otherwise. So if you don't want it to be careful if you don't want it to take effect immediately. The second type is called a springing power of attorney. This is a power of attorney that says it becomes effective after a certain event. Most commonly, the power of attorney will say that it becomes effective when the person becomes incapacitated or incompetent, but you could select a different event, like you want it to become effective if you move into a nursing home or something like that. But if the event is incapacity or incompetence, then the power of attorney should also identify who will make that determination about you. It can be your agent, your doctor, or anyone else you trust to make that incapacity call. The next thing the power of attorney should identify is what powers your agent has. Generally, there are two types of power that you can give. The first is general. This is a list of some of the general powers you can give, but there are some others as well. With these general powers, you are giving your agent authority to do like whole certain types of actions for you. So for example, you can give general real property power, and that lets your agent buy or sell real property for you. Other examples is you can give authority over all your stocks and bonds, bank accounts, government benefits, any combination of those or all of the above. The second type of power you can give is specific, and these give more limited instructions on what the agent can do. And generally you have to specify that they have these more specific powers. So again, this is not a complete list, but some of the specific powers you can give are to make a specific gift, create and change beneficiary designations on your account, or whether that agent is allowed to authorize more agents on your behalf. And then once you've decided that when you want your power of attorney to be effective and what powers your agent should have, you'll need to get a signed writing between you and the agent, which should be notarized. The writing can then be provided to specific organizations such as your bank or someone else. It can also be filed at the Register of Deeds office for safekeeping. If it is filed and then you later want to revoke it, you will also need to file a statement of revocation in the same office. If it is not filed, then you can revoke it by either creating a new power of attorney or physically destroying the old one. However, no matter how you revoke your power of attorney, it's important that you always tell your agent that they no longer have authority. And it's best to do that in writing so you have a record that they know they couldn't act on your behalf anymore. The next document we're going to talk about is the healthcare power of attorney. This is similar to a power of attorney in that it allows an agent to make decisions on your behalf, but it's different from a standard power of attorney in that it only addresses healthcare decisions. The benefits of having a healthcare power of attorney is that it lets you know who will make healthcare choices for you if you are unable. It gives someone authority to make decisions for you if your next of kin cannot agree. And it can also prevent the need for a guardian in certain situations. So who should be your healthcare agent? This is a decision you should put some thinking into because once you designate a healthcare agent, they will be able to make and carry out all health and mental health decisions for you unless the healthcare power of attorney also limits that ability. So you want to make sure this is someone you trust. You also want to select someone you think would make decisions in the same way you would if you were able to make them for yourself. And ideally, this will be someone you've talked to about what kind of treatments or healthcare measures you're comfortable with. And then finally, you can list a principal and alternative agent. If you do that, what will happen is they'll contact your principal agent first. And then if they are unable or unwilling to be the agent when the time comes, then they will go to your alternate agent. I think technically you can have co-agents with shared authority at the same time, but this is highly, highly advised against because if the co-agents can't agree on a decision, then basically just makes your healthcare power of attorney ineffective if no one has the ability to be a tiebreaker, and it can be a very stressful situation. So for the effective date and revocation, unlike a power of attorney, a healthcare power of attorney becomes effective once a physician determines that you lack capacity to make or communicate decisions relating to your healthcare, and it will remain in effect while you are incapacitated. If you want to revoke your healthcare power of attorney, you can do that at any time while you are not incapacitated by signing a statement of revocation or consistently communicating to your agent or your doctor that you wish to revoke it. Sorry about that. And then the last directive we're going to talk about today is the living will. A living will is a document that allows you to control decisions about whether your life should be prolonged by certain medical procedures if you are suffering from one of three conditions. And those conditions are incurable or irreversible condition. You are unconscious with a high degree of medical certainty you will not regain consciousness, or you have advanced dementia or another condition which results in a substantial loss of cognitive ability, and there is a high degree of medical certainty that the loss is not reversible. So just to reiterate, a living will only apply in these situations. But if you do find yourself with one of these conditions, what can a living will do? Basically, it tells your doctor what your desires are regarding life-prolonging treatment, such as life support machines, feeding tubes, or the use of a ventilator. And the document can tell your doctor that they either have a choice as to whether to use those treatments, or that no matter what, you don't want those treatments from your doctor. If you have a living will, you should give a copy of it to your doctor. It can be revoked at any time by signing a statement of revocation or by letting your doctor know that you no longer wish for it to be in effect. And if you do intend to revoke it, you should try to destroy all copies. And then almost to the end here, but I just wanted to quickly highlight a few things about healthcare powers of attorney and living wills. Since these both deal with healthcare, it can be a little confusing. In the simplest terms, a healthcare power of attorney gives a party of your choosing the ability to make healthcare decisions for you in the future, whereas with a living will, you are making certain healthcare decisions ahead of time for yourself and then just asking for them to be enforced. Additionally, you can have both a healthcare power of attorney and a living will, but if you do, you should make sure that the documents state which one is controlling. For example, if your brother is your healthcare agent, but you have a living will saying you do not want a feeding tube, the documents should clarify whether your brother can override your instruction not to use a feeding tube, or if you want to not have a feeding tube no matter what your brother says. And finally, it is the intent that advance directives be valid in any state. However, the laws vary. So if you move or you have health concerns and you're going to be traveling, it's best to check if your documents will be valid in another state. And then finally, just on a disaster related note, it's important to get these documents prepared as soon as you think you might need one. So you're not trying to deal with this when there's a disaster already forecasted. That's this little added stress you don't want to be dealing with at that time. You also want to make sure that if you have these documents, that they're part of your bug out bag, if you will. You want to make sure you're taking them with you if you have to evacuate for a disaster. Also, if you routinely evacuate to another state, you have family in another state, that's where you tend to go, you can already go ahead and check and see if these documents are going to be valid in that other state. And then Regina also kind of touched on this, but thinking about wills or advance directives can be difficult for people to do themselves. And it can also be really difficult for families to have these conversations. But it really is an important part of preparedness. If heaven forbid something happens to you in a disaster, or like Regina said, wills can have effects for generations to come regarding property ownership. So it's really important to just take the time and have these conversations with your family. I don't know if there's any questions. I don't know. Mary?
I'm sorry, I was just going to say, Kelsey and Regina, thank you so much. I was going to add that I did put a survey link in the chat. If anyone has a minute or two to fill out that survey, it'll be greatly appreciated.
All right, and if there's no other questions, if you'd like more information about legal aid or any of the topics we talked about today, you can visit our website at legalaidnc.org. We also have a great YouTube and Facebook channel with lots of information on lots of different topics. And if you'd like our assistance, you can call our helpline there. We do have heavy call volume these days, so if you dial that extension, you can leave a voicemail for the disaster relief team and we can get back to you as soon as we are able. Thank you all for being here today.